Hello and welcome everybody. This is Bernard Wolfsdorf, your moderator today on the second of our four-part series, our immigration webinar. Today we have three esteemed guests who are all experts in their field. My name is Bernard Wolfsdorf, and those of you who are looking at the screen are looking at a picture of me when I was 10 years younger. But I think that's legitimate in online arena today to use old pictures. But maybe next time we'll tell the truth and have the real picture up there. But thank you all for joining us. We had a very good registration, and we have, I was looking through the list, we have some very, very esteemed participants listening in, so that is a great honor and pleasure. We are today going to try and cater both for relatively entry-level folks and also try and throw some nuggets at those of you who are experienced veterans. Now, we do have a chat feature, and I am going to encourage all of you to ask your questions. If you can point out who they should be addressed to, if you're unsure, just put it in. But my area is pretty much the whole thing. Jor, obviously, corporate and securities, focusing on structure. Kevin of Wright Johnson is the economist, business plan writer, and expert, and Michael Gibson is the man who keeps us all on our toes and is the expert on due diligence, project evaluation, and quite frankly, pretty much everything else. So that's our team today. Welcome again. I encourage all of you to put questions in, and we'll try and get them answered. No topic is off menu, so please feel free to join us. Now, we will have our next webinar. That is, we're going to focus on a more advanced presentation on September the 18th, which will include setting up and operating regional centers. But I do caution we will throw in other hot topic items as they emerge, and there's certainly a lot of hot topic items nowadays. We will also have, thanks to my good friend Kevin Wright, we will also have a new speaker, Mr. Elliot Weiner. Now, Elliot Weiner is a private economic consultant and an expert on TEAs, targeted employment areas. We hear a lot of talk about TEAs, but this is actually a lot more complicated than people realize. So thank you, Elliot Weiner, for joining us on our September 18 webinar. Share this good news with your friends, and if you want to really learn the ins and outs of TEAs, and obviously why that's so important is the ability to reduce the amount of the investment from the current $1 million standard down to your $500,000, and obviously people are going to be far more inclined to invest $500,000 and get a green card than $1 million. So Elliot Weiner will be joining us on the September 18 webinar. Let's kick off here. This is a hype slide about my firm. Blah, really boring, other than maybe the email address. If you have any questions, feel free to call us, and that is what we call the mandatory marketing pitch. Let's move into some basics. I am going to fly through the basics today because this is not a basics. This is supposed to be intermediate, but for those of you who are brand new to the program, again, this program is not new. It was set up in 1990. for people who invest in a new commercial enterprise that will benefit the U.S. economy and create at least 10 full-time jobs. Look at those three critical criteria: a new commercial enterprise that will benefit the U.S. economy and create at least 10 full-time jobs. That's 35 hours a week. And Congress set aside 10,000 visas annually, and you may think, well, that's a lot, but it's really not. And this program has increased in popularity head over heels. There is no question in my mind that the quota will be fully used up for the next fiscal year. The current fiscal year finishes September 30th, but starting October, that 10,000 number will absolutely be used up, except my optimistic prediction is Congress will increase the numbers, and maybe we won't have the train wreck that we might otherwise have if those numbers are not adjusted. Now, the Immigrant Investor Pilot Program, by the way, it's no longer called pilot. It is unfortunately still going to sunset on September 30th, 2015. That is very, very soon, some 2 years away, but hopefully the Regional Center program will become permanent, and let's try and find some words here. So we will see some new legislation, in my opinion, that will address that and many other issues. So simple bottom line, you either invest 500 or $1 million depending on the geographical area. Is it a high unemployment area, 150% of the national average, or a rural area, 20,000 or less? And most important, create 10 full-time jobs. Now, this green card is conditional, much like the marriage one, so start to finish. Don't tell your clients this is going to take a year. Don't tell people this is a one-year program. This is going to take approximately 3.5 to 4 years. The adjudication times are currently ridiculous, absurd, what should we say? All of the above. So there's your basics. Two different types. You have your individual EB-5. This is for the person who really wants to run their business. They either buy a business, start a new business, and the critical point here is they will direct 10 full-time employees. That's W-2 employees, U.S. citizens, permanent residents, and other U.S. workers. But when we say few applications, we probably have to update that slide as well. I'm going to add the word relatively few because this is becoming the new flavor of the week, which is direct regional center programs, and then we're going to talk about potential hybrids as well, where you actually start on a direct and then apply for a regional center certification. So what is a regional center? Currently 388, lucky 88 there, folks. There have been over 100 approvals probably in the last 16 months, almost 100 approvals. A lot of approvals finally came through that had been sitting there for months, years. Most cases coming under the Regional Center program, and here's the magic reason: indirect employment counts. We're not talking about 10 full-time direct employees. We are talking about indirect employment counts through the use of an economist report. Sometimes they call it econometric report. I don't know what the right word is. Through the use of a economist's prepared report to predict job creation. So we are going to predict project job creation, and our expert of the day, Kevin Wright, is going to fill us in on some of the more juicy parts of these predictions. So what are we talking about next? How do we get started? We need to file a 526 petition, the form number, in regard to a new commercial enterprise, put in the correct amount of money, and that has to be from a lawful source. Oh gosh, that's another whole big one, folks. A lawful source, proving source of funds and the path of funds. All of my clients end up saying, why are you treating me like a criminal? Why are you treating me like a criminal? And the answer is, we're not treating you like a criminal. We need to document every penny of how that money got earned and how that money got into that investment. We don't want dope money. No dope money for EB-5s. And the money has to be at risk, okay? So what does this mean? Well, what is at risk? How much risk? 1% risk, 100% risk? This is another huge issue, particularly when we get into redemption clauses. So if we guarantee any return on the money, then that amount that is guaranteed is discounted from the 500,000. A lot of problems in that area. That is one of the in vogue issues that we are seeing at this time. Investment will create at least 10 full-time jobs. We've mentioned that, and the investor must be engaged in the management of the business. I get a lot of questions about this one. People are anxious, particularly in the direct. How much is engaged? Is policy formulation okay? And it seems that policy formulation on the board may be okay at the present time. So actively in the process of investing, people read that in the regs. Boy, don't go there. Maybe you can have your good business plan, but you probably really want to have invested, is my interpretation. Targeted employment area, the simple bottom line, there's the basic definition. You're going to have to sign on for our September 18 to hear the guru, Elliot Weiner, on TEAs, who's going to teach us the ins and outs of how this really works, so we can lock in our lower amount of $500,000. Matter of Izumi. Matter of Izumi has caused many nightmares for immigration lawyers. That's where in 1988, let's try one more time, 1998, the program pretty much hit a brick wall, and immigration reinterpreted, and it's been a battle, and what can I say? The rules were changed, the goalposts were moved around, people kicked, there was no goal scored, and it got pretty ugly. May 30th Adjudications Memo. For those of you who are new and you want to read one document, Google May 30th, stop that, Bernie, have them research properly, but seriously, you can just Google May 30th EB-5 memo, it'll come up. Enjoy the reading. It really has added clarity in a lot of areas, and of course it's opened up a whole bunch of new areas where we don't have answers, but welcome to immigration law. Sometimes it's like playing darts. You throw it at the dartboard and you hit a bullseye, and next time you throw it again, and what can I say? It doesn't even hit the dartboard. So unfortunately, there is a certain measure. Some of the other key precedent decisions, the investment must be at risk, We've mentioned that already. There are the four cases. Matter of Ho, and you see it spelled H-O. I used that joke before. Somebody actually laughed at it. But simple bottom line is Matter of Ho outlines what needs to be in a business plan and must be an equity investment. We can go into this in some more detail. Now, we are on to the famous, well, is he really famous? I'm not so sure. Perhaps infamous. No, stop that, Bernie. No silly jokes here. Jor Law of the law firm Homier and Law. I will concede he is the go-to guy. He's a little irritating. He's always nitpicky. Everything I say, he nitpicks. The problem is he's usually right. So there he is, Mr. Jor Law. And what he's going to talk about is a very interesting topic, the Jobs Act, and what the influence of the Jobs Act is on the EB-5 program in regard to the securities arena. So welcome, Jor, for joining us today. And he's giving a disclaimer that, you're not allowed to rely on this. He's not confident enough in his own statement. Stop that, Bernie. Stop picking on Jor. He'll bite back. He's known to bite back. But he needs to put in this legal disclaimer because he doesn't want to get sued. So, Jor, tell us, what's the story here? Securities in a nutshell. How do you fit securities inside a nutshell anyway? What are the goals of securities laws? What has this got to do with it? Aren't we doing EB-5 today? You may be on the wrong program. Tell me why this is relevant to what we're doing. Take it away, Jor.
Yeah, thanks, Bernie. So this is going to be interesting because the Jobs Act is something that you guys will all hear about because that's one of the hottest things in securities. But before we actually get into the Jobs Act, we ought to talk a little bit about securities. Now, basically, if someone invests in a company where they have a passive interest in it, they're not actively managing, they're investing in the securities. That's the general rule of thumb. And why is that important? It's important because most EB-5 investments, short of an entrepreneur coming in and starting up his own company, most of the EB-5 investments involve investments into securities. So there are two goals of securities laws, and they're designed to protect the investor. They're not designed to protect the company raising the money. They're designed to protect the investor. And the idea is that they should have adequate disclosure of all the information that they ought to have prior to making an investment decision, and to prevent fraud by the company that may lie or misrepresent in order to get an investor. This includes, by the way, for fraud, failing to tell the complete story or an omission. So if you, for example, say I have an excellent track record, 80 of my deals have been successful, but you don't disclose the 3 that have failed, that would be considered inadequate disclosure and fraud. So there are many, many laws around this area, and there's state, federal, and foreign laws, but primarily today we're going to talk about the federal laws that are affected by the Jobs Act. And then common exemption at the federal level is a Reg D. In EB-5, you'll find that there are really 2 well-known exemptions used. One is called Reg D, which is really a safe harbor for what is called a private offering, basically offering that's not publicly solicited or advertised. And then the other one is a Reg S offering, which doesn't have limitations on public solicitation, but does mean that it can only be sold to non-U.S. persons, and that sales efforts can't generally be made in the United States. So Rule 506 is the most common form of Reg D. Reg D is essentially a safe harbor guidance under the rule that says 4.2 exemption from the Securities Act that says, hey, if you're going to sell securities, you normally have to register. Registration is expensive, time-consuming process, so most people find exemption. Now 4.2 is the exemption that says, hey, if you do a transaction and it doesn't involve a public offering, you're exempt. The question now is, it's not clear what's a public offering or not sometimes. So Reg D says, well, if you do it this way, this way, this way, and this way, then under 506, it's considered to be a non-public offering. So here on this slide, you see some of the requirements that are tied to Rule 506. And I've bolded the one that says no general solicitation and advertising, because that's the one that has held a lot of people back from effectively raising capital, because they had to only go to the people that they knew, and you only know so many rich folks. But the Jobs Act changes all of that. Next slide. So the Jobs Act is officially called the Jumpstart Our Business Startups Act, signed into law by President Obama last year, April 5th. Now, specifically, there's various titles and sections to the Jobs Act, but in Title II, they specifically lift the ban on general solicitation and general advertising and offerings made under Rule 506, provided 2 things. All the purchasers of the securities are accredited investors, and that you have to take reasonable steps to verify that they truly are accredited. So what does this really mean? So prior to the Jobs Act being effective, and it's not effective yet, but prior to the Jobs Act, in this section being effective, you could do a private placement. You could not publicly solicit. However, to the extent that you sold to accredited investors, you could rely on a questionnaire that the person filled out saying that they were accredited, and that was sufficient. Under the new legislation, you essentially can publicly solicit if you want. You don't have to, but if you do, then everyone has to be accredited, and you have to take reasonable steps to verify. Next slide.
Before you go to the next slide, just can you, for the real rookies here, explain what is an accredited investor and answer my question? So I am a super rich guy. I'm worth 10 million, and I donate or gift $1 million to my 17-year-old kid who invests. Is my kid an accredited investor?
Okay, so accredited investor actually has several definitions, but for EB-5, there's only really two that matter. And one is a net worth definition and one is a income definition. And the income definition is essentially that you have an income that exceeds $200,000 in each of the 2 most recent years and a reasonable expectation of the same income level in this current year. Now that $200,000 figure goes up if you're adding your spouse in and counting joint income. That $200,000 figure then goes up to $300,000. Now that's one way. If you do that, if you meet that requirement, then you're already an accredited investor. Now, if you don't meet that requirement, you could also meet another one, which is that a person's net worth or their net worth with their spouse exceeds $1 million at the time of the purchase. And this excludes, however, the value of your primary residence. So if you're a millionaire because you own a $1 million house, then you're not accredited. If you're a millionaire notwithstanding the fact that you have a house, then you would be accredited. Now, for Bernie's question, where someone who's worth $10 million gifts his son or someone else $1 million, and then the question is whether the person that received that gift is accredited or not. Now, it doesn't matter how you get the money. If your net worth at the time of investment is $1 million, then you're accredited. So if someone gifted you money and there were no tax consequences at all to that gift to you, and at the end of the day you had $1 million sitting in your bank account, and you didn't have a primary residence, and you had no other liabilities, then you would be accredited.
Wow, amazing. You've really made what is super complicated stuff very, very clear. So tell us, how's this? I remember when the Jobs Act got passed, people were saying, oh, they won't implement, but they sure have, and we seem to have a slightly different landscape here.
Yeah, so the Jobs Act should have been implemented probably earlier than it really was. But, you know, over a year later, on July 10th, just about a month ago, the SEC came out with final rules for the part of the Jobs Act that allowed you to take general solicitation and advertising. Even though those final rules are adopted, they're not actually effective until September. So one thing I didn't mention before is that they say that bad actors cannot use Rule 506. So if you committed some sort of bad act in the past, and it's kind of beyond the scope of this call and this webinar, but if you're a bad person, you've done bad things in the past, and securities violations and things like that, then you wouldn't be able to rely on Rule 506. But assuming you're like the most of us and you can have a good clean record and you're a good honest citizen, then these rules would be available to you. And of course, what they really did is they just adopted what the Jobs Act said, which was that you could publicly solicit, but now you'd have to verify and you'd have to take reasonable steps. The SEC did give us an idea of what reasonable steps would be, and they suggested that reasonable steps would, not be necessarily a hard, fast rule, but kind of a facts and circumstances rule, so that you could look at the nature to determine whether reasonable steps were taken. You would look at the nature of the purchaser or the type of accredited investor that the purchaser claims to be. For example, if someone comes to you and says, I am a registered national bank, that's, they're probably a accredited investor. You might just verify that they really are, but that's about it. The amount and type of information that the issuer has about the purchaser. If you've done deals with them for the last 10 years and they've always been accredited, and you've always known them to be accredited, then it's not suddenly the law comes out and you don't know, you're unable to rely on that past belief. So that might be a reason. Nature of the offering. If the offering amount, let's say the offering minimum amount was $5 million. Well, the people that are investing in this $5 million business are probably accredited investors. Not guaranteed to be, but probably. So those are some of the reasonable steps and what you would have to think about as you're thinking about what constitutes reasonable steps. Now, the SEC did provide a non-exhaustive list of processes that would constitute reasonable steps to verify, and they gave 4 of them primarily. And if you did one of them, then you could be reasonably assured that you had indeed taken reasonable steps. But the SEC was very clear to say that you didn't have to take those 4. You could come up with reasonable steps anyway. Now, because they have gone out and they have laid out what is actually reasonable, you'll find that most of the market, or much of the market, is afraid of uncertainty. Because if you do it the safe way, you know that you're in compliance. And if you don't do it the safe way and something goes wrong and they determine you haven't taken reasonable steps, then you might disqualify your offering. So they provided an income method for how you could verify that someone's income met the minimum amount. And they provided a net worth method, and not rocket science. They just said, look at W-2s, look at a personal statement and things like that. They allowed for third-party verification, allowing for you to essentially hire a licensed broker-dealer, investment advisor, attorney, or CPA to provide verification services. And then the last one they said was kind of a proviso to help folks that were accredited investors in an existing deal that were reinvesting in the deal, essentially.
Before we jump into this next slide, Jor, I wonder if you can give me some bottom line impact in the field. I know we're not effective until September 23, but you've got a crystal ball there in front of you. Rub that ball and tell me, how is this going to impact the activities of regional centers in terms of marketing in the United States? And will it impact regional centers in terms of marketing abroad? And what impact will it have on, for example, marketing direct EB-5 programs? Tell me what you see in the landscape a year from now.
Yeah, I think that it's hard to say. I'll answer this by giving you some insight to EB-5 and non-EB-5 folks. So outside of EB-5, the clients that we're talking to, I'd say over half of them have decided that they are not going to take advantage of the new laws, that they feel that it's going to be more hassle than it's worth, and they don't need to publicly solicit. Within EB-5, I think that we're hearing more interest in raising money through public solicitation. The reason why I think is because outside of EB-5, a lot of people that are playing in the capital raising field, short of the ones that are early stage, a lot of them already are dealing with relationships that they understand, and they're pitching to pension plans and things like that. So it's a very closed universe. So they're less likely to want to change their behavior, especially when the laws may be a little bit uncertain about what the SEC might impose in the future with proposed amendments. In EB-5, because people are trying to get a mass group of investors, I think that they will try to do this a little bit more. Our firm is being cautious in telling people that it won't be so easy to do it, and there are a lot of implications. For example, if you can publicly solicit, that's fine. Reg S lets you publicly solicit. Reg D will now let you publicly solicit. However, just Reg S, if you publicly solicit in the U.S., you will violate your Reg S exemption. So unless you do it very carefully, you may end up getting rid of your Reg S exemption and relying only on Reg D. Now, Reg D has its own issues. For a short period, there's going to be a window of opportunity where you can do public solicitation and not really have to worry about the proposed amendments that come out. But in the long term, the proposed amendments that come out might make it not worth actually taking advantage of the public solicitation.
Jor, very, very helpful. Let's get another perspective and just bring in Michael Gibson, our due diligence expert, EB-5 Info. Mike, what are you seeing in terms of the impact of the Jobs Act and what I'm going to call heightened interest of the SEC in the EB-5 program? What are your bottom lines? What are you seeing right now, Michael?
Right. I'm going to start off by agreeing with everything that Jor has said. We actually don't think that the new regulations, when they finally get implemented, are going to materially affect the raises in the EB-5 program, simply because there was a substantial shift in the marketplace from using Reg D a few years ago to now, and I would like to hear what Jor says, but I think almost 90% of the EB-5 offerings are Reg S. So I think by and large the new Jobs Act is not going to affect really the way things are done in EB-5, because people are not soliciting in the U.S. Certainly the major, the biggest regional centers have essentially given up the U.S. market because of these issues of solicitation and filing the Form D, where you have to disclose all of the payments that you've made to third parties. And as most of the people in this industry are not registered, including the finders and the agents of these centers and the immigration attorneys who may be getting compensated for referring their clients, the regional centers were reluctant to get involved with certainly having a Reg D in place and then possibly having to file a Form D. So I don't think actually the Jobs Act is going to change much in the EB-5 world. As far as the SEC now coming in, well, that was a material shift in the landscape with the Chicago action, and I think we're going to start to see more of that as some of these projects start to fail and the investors start to complain. So on the one hand, the regulation is coming, whether it's from the federal authorities or from the state agencies, and I think that can only be a good thing, certainly to weed out some of the misrepresentation. But as far as doing the raises, I actually don't think it's going to affect that much the deal flow.
Michael, let me ask you. That's your slide up. The slide I have up here is your contact information, EB-5 info, and your telephone number. But above there, it's got this. This report has been prepared by blah blah blah, a licensed financial advisory firm, FINRA card number 157403. What is this FINRA card? And did you buy it on Alvarado Street for $25?
Yeah, I don't know how things work in California, but no, this is we're a registered investment advisory firm. It's a process that investment advisors need to go through. We actually have two CRD designations, one for U.S. advisors, which is the firm, and the other that covers the analysts. So I think basically what this designation means is that we have to comply with certain FINRA regulations. Now, for those who aren't familiar, FINRA is the self-regulatory organization, the SRO, that does all the monitoring of the people in the securities industry, essentially for the SEC and to some extent the state regulators. So it's an organization that puts in place consumer protection. So we talked about on the last webinar, on the introductory one, that the primary function of the SEC is to protect investors from certain practices that could cause them harm. And I think FINRA is looked at as trying to regulate the activity within the industry participants. So this is our registration to disseminate financial advice and give recommendations on project selection.
So the way I understand it right now is Jor explained to us how the SEC has created a framework to protect potential investors. It's highly regulated, and there is a certain class, because I get this question every day, 50 times a day, so tell me which is a good project. And I tell everybody, look, there's two critical elements if you're going to invest in the regional center. Number one, you have to select an appropriate project that you feel comfortable with, and that is, I guess, where we do due diligence, and that is where technically, not technically, but legally, the only people who can really give advice in the financial arena are people who have a FINRA card and this kind of credential. Is that correct, Michael?
Right, and even within our industry, there are people who are registered representatives, registered reps they call them, and those would be a Series 7 or 79. There are a few of those in our industry. And there's the broker-dealers, which supervise their activity. Even they don't have a fiduciary role to the investor. They're typically trying to create an efficient market, so their primary client would be the issuer. They would be the people that Jor and many of the other service providers would work with. So we don't work with the issuers. We don't work for the regional centers. Our clients are the investors, and I think that's an important distinction to realize, that in this industry you really only represent one side of the transaction or the other. And I think where immigration attorneys get into trouble, as you've already mentioned, is possibly trying to represent both sides, where you may have clients that you've done work for on the regional center level, given them investment advice. They may even have retained you to file the regional center application, but on the other hand, you're also representing the investors. And I think for those attorneys, it's especially important that they maintain a very clear and distinct role. Otherwise, if they find themselves in the position of giving advice to both the issuers and then putting investors, their clients, into these projects, and something happens, I think there could be questions regarding their allegiance and certain ethics and conflicts of interest.
Thank you, Michael. So going back to you, Joe, I cut you off from your last slide, but let's assume that the attorney or other person oversteps the very clear guidelines of the SEC, and somebody calls me and says, which project do you like? And I say, well, I like ABC project, and the person goes in, and what can I say? It happened to be the South Dakota beef packing plant. I don't know what it is with beef packing plants, but I guess Americans do not particularly like cutting up cows. And as a result, there's quite a few undocumented in the slaughtering business, chickens, cows. We had the fiasco of Postville in Iowa. I know Tyson Chickens had, I believe, some issues a few years ago. Pardon me if I got the wrong chicken processing plant. But the bottom line is that investing in slaughterhouses has had mixed results. And what if I, as the attorney had suggested, oh, here's a really good project, and put it in beef packing, and oh boy, what happened there? So, Joel, going back to you, what are the consequences of an attorney clearly overstepping the mark and doing what Michael Gibson is registered and licensed to do? What are the consequences for us, Joel?
Well, I think it would, it's not always going to be the case that it's that clear. There are certain kind of leeways that an attorney gets, if it's ancillary to their providing advice, and I think that some attorneys, an attorney saying that they're familiar with the project and they like it is not necessarily exactly the same as they're familiar with the project, they like it, and they advise you and recommend you to invest in that one. So I don't think that it's always going to be that crystal clear. But presumably, if the attorney overstepped the boundaries, at the very least, there could be, from the investor side, there could be a suit to recover the investment and rescission, essentially, that the investment advisor would, also kind of have liability for. But from the government side, it could be a action, essentially from the Attorney General or other authorities alleging that you had provided investment advice without being properly registered.
Joel, your last...
You've
sorry.
Taken Michael, do you have anything to add on that, or you think that's a reasonable enough summary for the purposes of the call?
Yeah, we went over this a bit in the beginners webinar last month. I think the attorney really has to be careful, and again, we're looking at this from a liability perspective because you're absolutely right. There is a bit of a gray area, but I think where the litigation, if it comes, would come into, did the attorney give advice that the client then used to make an investment decision? And even I've visited probably more immigration attorneys than I care to admit. They're great people, but the thing I see when I walk in their offices, I see oftentimes the regional center brochures on their coffee tables, and the investors in the waiting room, they'll pick them up and they'll come into the office, and the attorney is very careful about saying, listen, we can't give recommendations. We happen to know about these people, and we think they have a good, what the common phrase is, a track record. And just by doing that, if the client invests and then they lose their money, perhaps a residency petition, they will go and they will tell the litigator, this attorney told me to invest in that. Now, that may not be the way it happened, but you're going to get into a he said, she said, and I think the more that the attorneys do to not influence their client's decision unless they've done all of the due diligence, probably the safer they'll be.
Yeah, thank you, Michael. I think that's really helpful. And what I try to do very directly, and I have this, as I say, 10, 15 times a day, to the extent that I have studied the documents and filed cases, I obviously become familiar with various projects, and I might talk about some aspects of the project that I'm familiar with, but I will always tell them that they have to hire an appropriately registered and licensed financial advisor to kick the tires and do the analysis. I will, however, provide what I call immigration advice in as much as issues such as redemption clauses, such as my review of the job count, although to some degree we're very reliant on the Economist, and other clear immigration issues in terms of, do we have deference because we've got 526 approvals. So I will advise on clients at the end of the day need guidance, and they don't come to an immigration lawyer for the immigration lawyer to say, well, I'm sorry, I can't help you. So what we need to do is provide advice in the areas where we do have the expertise, and then in the areas that we don't, we have to, in my opinion, bring in a specialist who does understand the nuts and bolts of the procedure. So, Jor, let me turn to your last slide. Sorry, I kind of cut you off there. Proposed amendments in regard to the Jobs Act. What is this all about?
Yeah, we don't have to get into this too detailedly. It's just, an idea of.
Can I be a little rude and just ask you to pick up the volume? You need to be a little bit more like Mick Jagger in the mic.
Are you sure you can hear me?
Maybe I'm deaf. It's just that Michael Gibson is so much clearer. We can hear you just a little louder, if possible.
That's interesting. The phone is next to my mouth, and I'm speaking loudly.
Then it's my hearing.
Anyway, this slide is really there just to show you that the Jobs Act implementation of the general solicitation rules is not complete. They've done the bare minimum that they needed to do, but they also have additional amendments they'd like to do and pass down to kind of supplement the Jobs Act. And some of these are meaningful because the Form D, sure, okay, under the current Reg D, you got to file your Form D anyway. However, they want to amend the Form D so that there's additional information that they collect. The Form D has to be filed before your offering, not after your first sale, and it has to be amended after closing. This all does something important, which is just collects information about your deal. So to the extent that you don't want as much information about your deal out there, then maybe you wouldn't take advantage of the new legislation. The other thing is that they did suggest that additional language and legends would be required. To comply with that, you may have to change how you do your offering documents. It may increase your cost a little bit for your website and other offering materials. And then also you'll have to file your materials with SEC. If you do a Reg D offering right now, you don't have to file your materials with SEC. If you do the offering under the new legislation, they're suggesting that they want you to file materials with them. Now, who knows whether the amendments will get passed as proposed or not? But if that's the case, I can imagine that there are quite a number of companies raising money that wouldn't want their materials or lack of materials to be filed with the SEC.
So what you're telling me, and I like to make it simple, is that, and particularly this last point, the requirement of having to actually submit your marketing and advertising materials to SEC is really going to gut this proposal, because folks just aren't going to want to do that. Is that an accurate speculation?
I think a lot of people are not going to want to do that, especially if they've try to do their EB-5 offering on a tight budget and maybe didn't afford their professionals the courtesy of providing exhaustive diligence and whatever, so that even their own professionals don't know to the extent of how much was disclosed or not disclosed, and many, I think, issuers or companies would be reluctant to follow their paperwork.
So wonderful, thank you. I greatly appreciate that. I'm going to sort of skip through. I'm watching our time here, make sure that we cover everything. We've got some very basic stuff in here. What is a regional center? Not merely a defined geographic area, but is rather a business entity that coordinates foreign investment with an approved geographic area in compliance with EB-5 statutory, regulatory and precedent decision. Reading slides is so boring. The bottom line is nobody really knows what regional center designation currently means. The memo changed this very, very considerably. So it's kind of confusing. They do not have sole jurisdiction over a specific geographic area. In fact, several regional centers can cover the same area, have overlapping boundaries. This next point is pretty critical. The purpose of the regional center. What is the purpose? This was brought in 1993 to help kickstart the program, is to promote economic growth through increased export sales, improved regional productivity, increased domestic capital investment, and, of course, most important, job creation. Just jumping over to you, Kevin, you are what I'm going to call one of the gurus when it comes to setting up regional centers, and the next September 18 program is going to be focused pretty much exclusively on setting up regional centers. I have the privilege of working with you, and I am always just blown away with the extent of your knowledge. But Kevin, just, unprepared here, throwing out a question. What does a regional center mean today? What does it mean to get a certification and an approval? What geographic areas does it cover? What NACE codes does it cover? What if the specific industry of the approved regional center is different from the new project? What does it mean in terms of all these various regional center approvals that have been popping out recently? What does it mean for the regional center, and what does it mean for developers and new projects coming on the market? Nice general question, Kevin.
Sure. Well, traditionally a regional center is defined by a geographic area that's usually defined by a grouping of counties. You will see regional centers that are as large as a state or several states. However, those regional centers did gain designation some time ago, several years ago, and today to get a regional center that covers an entire state would be very difficult. Typically, the way you determine the geography of a regional center is guided by your economic analysis, and it has to show that the region you're applying for has interplay, or the economies of the various areas or counties all work together. So typically that would be done through either showing an MSA, or a metropolitan statistical area, to determine that area, or you can do it by showing commuting patterns, or which are basically showing that, let's say you want to do projects in Los Angeles. Well, you know that there are a significant amount of people who commute to work in Los Angeles from Orange County, so you would include that county as well in your regional center. That would then be defined as Los Angeles and Orange County combined together. Now,
sorry.
In addition, traditionally it was defined by a grouping of industry sectors. So you were approved to do, let's say, assisted living facilities and hotels and restaurants, if that's what you applied for. However, after the May 30th memo that came out, the industry sectors that you applied for basically went away. So now they said, well, if you're approved for a regional center, although your designation letter will still show that you're only approved for hotels and assisted living and restaurants, if you find a manufacturing project that you want to do, then you can go ahead and do that project and basically amend at the same time you do your first I-526 without a pre-amendment, meaning you can do almost anything you want at any time. Dealing with geography, the May 30th memo also said that you would have the ability to do projects outside of your region. However, it's not quite so clear as to how that works, because the fine print says that you also need to show that your project will also affect the regional center that you were designated for originally. So therefore, there are not many tests of this because it just came out, but the thought being is that, well, if you're approved for Los Angeles and Orange County and you find a project in Ventura County, which is contiguous to Los Angeles County, then you may be okay if you can demonstrate that it's going to affect the economy of Los Angeles County as well. But you could not do a project in New York City because that is so far away from your designated region that the economy will not be affected by simply putting up a hotel in Los Angeles. Is not going to benefit anyone in New York City.
Wow, Kevin, that is amazing, and thank you. You've really added clarity to what is a regional center. Of course, we don't actually fully understand how far we can push the envelope in terms of geographic area, but certainly contiguous counties would seem to be appropriate if we can show that there will be an impact on that particular area. Regional center versus direct EB-5, this is, of course, a critical question. It always comes up. The key point here, of course, indirect jobs versus direct job counts, and the requirement that, or the permissiveness that an investor can have a less active role when it comes to formation and management of the business, generally with a more of a policy role. Kevin, this concept, a regional center affiliated project may count both direct and indirect jobs. To some degree right now, the name of the game really is about job counts, direct and indirect jobs, which ones you can count. So regional center affiliated projects may count direct jobs of full-time W-2 employees as well as indirect jobs. In a nutshell, and this is another very broad and silly question, explain how this indirect job count works within the framework of a regional center.
Well, sure. Basically, in a non-regional center, EB-5 context, you can only count the direct jobs and you cannot take advantage of indirect jobs, which limits the amount of projects that you can do, because in a lot of industries, you're not going to get enough jobs directly to be able to fund a significant portion of the project through EB-5. However, in a regional center context, you can include the indirect jobs as well as the induced jobs, which are a subset of the indirect jobs. To back up for a second, the basic, definition here is that a direct job obviously is someone who works directly for the business. An indirect job is a job that is created through the supply chain of delivering products or things that are used by the business. And an induced job is when you have direct employees of a business. They then can go out and spend money in the community and also help to create other jobs, such as they may go to the grocery store, use their paycheck to buy groceries, helping to employ people at the grocery store. So the amount of indirect jobs varies from every geography and every county in the United States, as well as every industry that you're in. But you can get a significant number of extra jobs through indirect employment or induced employment in those particular industries. In particular, things such as manufacturing or base level type industries will have higher multipliers or higher level of indirect jobs that are created due to the fact that they use more of the supply chain. An auto manufacturer is going to indirectly employ a lot more people than a fast food restaurant. However, whether you're in a fast food restaurant or manufacturing, you can count on a significantly more higher number of employees indirectly than you could with just counting direct employees.
Kevin, there is a rumor out there, and I don't know if it's true, but there's a rumor that you've actually prepared over 500 of these economic reports, making projections. And when I say you, it's your company, Wright Johnson. Firstly, I ask you to either confess or deny that claim that you've actually done over 500 of these.
Well, I would say that we've done several hundred. The exact number I'm not positive of, but we've done quite a few of these reports over the past 6 years.
Okay, so this is not the first time, and as you can see, Kevin is extremely knowledgeable in this particular area. Talk to me a little bit about the input-output models, RIMS2, Implan, Redine, and I'm going to sort of go into this a little bit more later on in the program, but it popped up in my slides. So explain how exactly these things work in terms of indirect job creation, these forecasting tools.
Sure. All input-output models work basically on the same principles. So there are three main models that are used generally in EB-5, which are RIMS2, Implan, and the Redine model. All the models basically use algorithms to calculate indirect job creation through an input, meaning that you could either tell the model, hey, I'm a restaurateur and I know that I am going to employ 50 people at my restaurant. And I can input 50 people and calibrate the model to your specific geography and do some other things that will then output how many indirect jobs would be created. And that model would be accepted by the USCIS. Now, you can also input to that model expenditures or revenue, meaning that if you know in a construction scenario that you're going to spend $10 million on hard construction costs, then that model will calculate both the direct and indirect employment that will be created by your construction project. So there are two basic inputs, which are either the expenditure or the direct employment that will get you the output that you're looking for, which is the total amount of job creation that can be used for EB-5 purposes.
Kevin, thank you. That is really helpful. So on the one hand, For a developer, the options really come into two or three areas or two or three choices. The first one is the project developer could set up their own regional center to raise capital for their own projects, but they also may have a project sponsored by a non-affiliated regional center, the so-called rent-a-center concept that we are seeing. You can set up a center or you can affiliate with and rent a center. It's very, very important. I always get this question, and so many potential investors, which is, can you recommend a regional center? Well, the issue is really double. Number one, the question is, can you recommend a regional center and a project? Or more importantly, can you recommend a project? And again, of course, we cannot recommend a project. We could recommend someone like Michael Gibson to evaluate a project or somebody appropriately qualified to, in fact, evaluate that project from a financial point of view. We, of course, can talk as immigration lawyers about the regional center. We often know who the people are. We know a little bit about their track records. Again, of course, past performance is no indicator of future results. But the simple bottom line is that there are certain established regional centers, and it may be that being established is not a positive. It could be a negative. I've spoken about a beef packing plant, nice and established with 526 approvals. Those folks are in a very difficult predicament at this time because those with approved 526s, the company basically has gone bankrupt, and I understand pretty much all the employees have been laid off, and the investment has to be sustained. So the 829s are going to be, that is the application to remove conditions, are going to be more than challenging. They're going to be brutal. And in fact, these folks are going to have to pony up another $500,000 to put it in a new project, file a new 526 is my general prediction, or they are going to face removal proceedings. The other word for removal, of course, is deportation. So, choosing the correct project just cannot be overemphasized. It's not just the regional center, it's the project, and that's why we've got experts here today with us. We have Jor Law, who's going to advise us and has advised us on appropriate securities matters, setting up the appropriate structures, doing all that corporate work. We've got Kevin Wright, who does business plans, economic modeling, and is the guru who can talk to us about job projections, which really is at the heart of all of this. And we've got Michael Gibson, who is the absolute guru when it comes to due diligence and evaluating projects. And then, of course, we've got yours truly, Bernie Wolfsdorf, who is merely here to provide entertainment and bad jokes. That is my role, and try and make this all work. So this, by the way, is the second in our four-part series. We actually did a series last year. We will be doing our next one on September the 18th, where we will have a new guest. We are getting over... We're getting very, very good attendance on this. I'm also going to remind you and encourage you to ask questions. We will be answering your questions at the end of this presentation, so please tee up your questions with your chat function, and we will be available to answer all your questions. So we're now moving into the issue of due diligence. Due diligence, D-U-E, D-O-D-U-E, diligence. Do due diligence on your due diligence people. How many times can we say this? Here are some of the questions. What is the immigration track record, number and type of amendments, loan or equity projects, RFEs or notice of intention to revoke? RFEs are normal in this industry right now. Notice of intention to revoke, oh, that's a little bit ugly. The N-O-I-R sounds like a nice French term, but it's not. It's nasty. notice of intention to revoke after you've got your pre-approval. The other one, NOIDS, notice of intention to deny. Horrible, horrible, horrible. But actually, we see a few NOIDs, and quite frankly, we can usually get past them and still get our approvals. The overall bottom line, the reason to be optimistic is approval rates are still running at about 80 or 85% on 526s and closer to 90% on 829s. But, you know, statistics are a very dangerous area, because if you're one of the 15% with a denied 526, that's no fun. And one more, you know, the statistics today do not tell us much about the statistics tomorrow. We have over 6,000 of these cases pending at the California Service Center, and, you know, that statistic could change dramatically, particularly as a result of the new, not so new, tenant occupancy problem or tenant occupancy headache, which which Kevin will talk about later. So how is job creation tracked? TEA designation, we're going to go into that. Again, some of the issues: do you have your TEA letter? Escrow policy, how much, when is the money released? What is the refund policy? Does the money go straight in? There's a percentage of once is the money released from escrow when you have a certain percentage of approval. Reporting on the status of investments, how often is this regional center reporting to investors? On a monthly basis, every 60 days, quite common. Other successful capital raises, you have a track record of doing this. Affiliated with any government entity, what does that mean? Not always a lot. Some of the projects that have imploded were affiliated with. Complied with the 924A. This is a requirement to do an annual filing. Those are just some of the questions that should be asked when choosing a regional center and doing due diligence. So let's flip it over to our expert on due diligence, Mr. Michael Gibson. This is your favorite phrase, and you're the man who can really give this term some meaning. So, Michael, take it away. When we flip this term due diligence out, what is it we're really talking about, and what is it you do when we hire you to undertake project risk analysis and due diligence? Take it away, Michael.
Great. Thank you very much for that, Bernie. So just to give some historical context for the listeners, the term due diligence actually did not come into the vernacular until 1933, when the United States passed the Securities Act of 33. It's kind of like in immigration, you have the matters of Ho, Sufisi, Izumi, these landmark decisions. Well, shortly after the Great Depression, the Securities and Exchange Commission was created, and one of the first laws that they enacted was this Act of 33, and in there, in small print, in Section 11, was this term due diligence, which nobody had really used before. And I think there's some analogy to the EB-5 program, because I think we're at a very similar stage in our evolution. That the EB-5 industry, for being around as long as it has been, really has only been in the mainstream of capital markets for the past 5 years or so. And we are very similar to the equity markets back in the late 20s, early 30s, where essentially nobody did any due diligence. So the SEC saw this as a problem, and they instituted this rule. And basically what it gave was the broker-dealers a defense that if they were sued for any wrongdoing, they could use this act to protect themselves. And basically what it said is that if they do certain things, and I think the one that we keep referring to is something a reasonable person would want to know about regarding the investment, if they disclose all of the material facts and all of the important information about the offering, and they do that to confirm what is being presented to them, then I think they stand to be in a safe harbor. And I think the analogy that I would use with the EB-5 industry is that right now I would say there's almost no due diligence done, and certainly not from the Chinese side, when you have the agents who are representing projects to clients, they oftentimes will omit material information and they will not give all of the facts regarding the offering. And I think that's putting the clients into a very precarious situation. So the point is that if it's not happening offshore, I think for the listeners on the call, it's inherent that if they have a client who's sitting in their office and they're advising them on which direction to go, that if they can't do it, that they find somebody who can do it to put themselves and their client into that safe harbor.
So the other phrase that one would use is called CYA, cover your whatever. Okay, so
well, you know, I would actually use it in more due care, and I think that's the phrase that we see. There are attorneys who use our services and use others' services, and I think the word that they use is due care, and it's just showing that you care about your client's interests, and I think if that's being done, then your liability is going to be much reduced.
Well, you are, gentlemen. Due care, due diligence, and due diligence, and due care, and that will hopefully, with the appropriate qualified professional, give you some coverage as an attorney. But regardless, because it's not just attorneys on this call, we have potential investors, we have developers, we have the full range. This is nevertheless a critical aspect of the EB-5 program. Now, Michael, one of the biggest issues with regard to EB-5, so we've gone through this program, we put in our investment, and you know, the person's got their conditional green card, they've now got their full green card, and they want their money back, okay, consistent with the concept of investment is the idea you get your money back. And a lot of developers are, you know, they use terms like, I keep hearing this word, guarantee, and clients, you love using the word guarantee. And the problem is the money has to be at risk. So if there is going to be a redemption, and I was actually having not an argument, let's call it a discussion with Jor last night about 1 o'clock this morning, you know, on a redemption issue, and in the proposal, Jor indicated that it would be the lesser of, let's just make up the money amount, lesser of $300,000 or fair market value. And I was saying, yeah, that's logical, but, you know, CSC in adjudicating may in fact think that, you know, there's a guaranteed fixed amount redemption, and there isn't, because it's the lesser of $300,000 or fair market value. Fair market value may be zero. So in fact that money is all at risk, and Joe of course is 100% correct, and yet me, the immigration lawyer, is nervous because sometimes you have examiners who are less familiar with these concepts of fair market value and redemption provisions, but this is a critical aspect of the program. So Michael, explain to me what is fair market value, and talk to me about redemption issues as well, because that's the issue which, by the way, is at the center of attention on what I'm going to refer to as Director Mayorkas's the investigation that's floating around that one. And Director Mayorkas, a great advocate of the program, one of the most brilliant attorneys that I've worked with, is currently having to deal with a certain matter relating to redemption. I'm not going to comment on it, but it is nevertheless a very important aspect of EB-5. And by the way, in the May 30th memo, there is considerable clarity as to what form of redemption is permissible. This is a separate topic, but Michael, can you comment, sir?
Right. On the issue of redemption, that's not our specialty. What I would say on that is that the market in China is expecting the issuers to come in with some sort of a redemption guarantee that would satisfy the USCIS requirements. And I agree with you and Jor, or probably more with Jor, because you know, if you say it's the lesser of 0 or 300,000, well, if you get 0, that's what you get. So from my standpoint, what we view as, and again, we represent the investor, so what we would do is we would say all of these passive investments are basically, the cost is about $550,000 plus or minus. But although all of them cost the same, you're not getting the same, at least initial projected value or current or market value. Oftentimes the market value at inception is zero, so what you have to do is some projections and some asset valuations. But what our question would be is at term, when the loan is due or when the asset is due to be put into the market and hopefully everybody can exit, our question would then be at that point, what do we consider the fair market value to be? And that requires some statistical and mathematical analysis. But the point of all of this, and again, bringing back the concept of due care and due diligence, is that if the investor or somebody who represents the investor does not do that at the inception, then they have no idea what the potential value is. And the problem that we're seeing is most of the projects that we see, we estimate, having done this analysis, that very, very few of these will be ever able to return anywhere near the $500,000. So from the outset, when we view a lot of these projects, I would say over 50% of the projects, we do not see any possibility of a return of full capital. And I think that's the issue for the immigration attorneys who are on the call, is that if your clients are going into these projects and at the inception there is very little market probability that these investments will be able to return the investment, you must assume that at some point, if your client gets back $50,000 or $100,000 on a $500,000 investment, regardless of what happens with the green card, they are not going to be happy. And you know, I don't know what defense they would have, even if they said, well, we don't advise. They're probably going to get involved in some sort of an action. And our point is that if they had done this at the inception, they would probably say to their clients, listen, we've done this analysis, and our estimation is that the market value at term is only going to be a fraction of your current investment. Are you okay with that? And if they say yes, then I think they're probably in a better position.
Michael, very helpful, and I realize that I'm flipping your slide on its head, talking about fair market values on the tail side, and you're talking about fair market values going in, where you're making some kind of projection and looking at what as part of your due diligence analysis. I just happen to have that redemption issue on my table and wanted to throw it out there because it's sort of a hot topic, and obviously doing the evaluation up front is critical as part of your due diligence issue. I'm going to run through your slides. Just tell me to flip when they come up, and we will keep going. I'm a little cognizant of time here because I do want to get into the questions as well.
Right. The only thing I'm going to say about this one is that nearly 100% of the projected, let's say, either fair market value or future valuations that we see in the pro formas that are presented by the issuers are based on no sense of reality. When we look at to what the actual market is, we see a very large disconnect, and I'm afraid that the attorneys who review these documents may not understand that the asset that is being created may not have the market value that is being presented to them in the marketing material, and without doing a separate independent analysis, they may not really be they may not understand what the risks are to that asset actually creating the value it's projecting to create.
Well, I think it's absolutely critical that we focus on this issue to the extent that it's possible, and it's quite correct. When you start the case, the client's just focused on the green card. They do ask about, am I going to get my money back? But quite frankly, if you haven't done this fair value assessment up front, chances are you're not going to have much protection on the negative side, on the tail side, when the green card has been issued. So, Michael, let's run through some of the positive aspects with regard to a particular deal or a particular project when you do this evaluation. What are these 7 things that you look at? And then we'll go into what are the negative aspects. Give us the positives and negatives. What is it that you do for a living when you're evaluating a project?
Right. I think the number one issue that we see is the availability to other forms of capital. So the reason why most projects will fail, either to create jobs or to return principal at term, is because that the developer, the issuer, simply ran out of money. And it could happen at any stage. This is, I mean, you are wise beyond your years in using the South Dakota example here, because this is exactly what happened. They built a state-of-the-art production facility. It's probably the best meatpacking plant in the United States. Unfortunately, there's not sufficient market demand to keep it afloat, and they don't have any other forms of access to other capital. So you've already covered it. They're going to do the massive layoff, and they may or may not come out of the Chapter 11. The point being that when we see a project, the very first thing we do is we ask them, do they have other forms of available credit or equity or other capital? Because if they don't, if EB-5 is, and is often the case, is the last hope for many of these people, then if they run into any sort of difficulty, and any developer will tell you there are always unforeseen circumstances, if they run into any difficulty and they don't have cash to get them out of that, or weather the storm, then there's a very high probability that both the jobs will be lost and the asset will not exit.
Michael, excellent. Thank you. That's capital stack, and how much additional capital do they have available to run the business? That often is what will drive companies out of business, is cash flow issues. So several of the other things, and we probably will go into these in more depth. I'm just watching my clock here. Developers' equity is certainly a big issue that investors are going to look at this point, and having endorsements by politicians usually meaningless. Negative circumstances, Michael, if you want to, what are your turnoffs when evaluating a project?
It's somewhat similar to the positive, in that if they have other, we like when you see a deal and it has many different forms of capital involved, developer, either it's GP equity or it could be bank loans. We have no problem with bank financing or other forms of debt, bond financing by the municipalities. Any of these things indicates to us that other people have reviewed the deal and they like it. So if you have a Wells or a Bank of America or other lender in the mix, to us that brings us great comfort, because they have, I'm speaking now as an ex-Citibank guy. I can tell you, when we looked at a deal at Citi, we would do extensive due diligence and investigations into all aspects of it, because the last thing a bank wants to do is lose its money. So if you have a bank involved in the deal, or a municipality or other lender, then typically that means there's other sets of eyes on that. I think really the one negative that we would say is that when you see a deal that is 100% financed by EB-5, that raises for us a lot of red flags, because it says to us simply that they can't use the lower cost of capital excuse. All they can say is that we have no other sources of funding, and for us that would be a huge issue or concern.
By the way, I've just shown Michael's, and I've cut off some of his slides, but I'm going to call them teasers, because our next program is on September 18, I believe. This is Michael's 2-page due diligence checklist. It's amazing. It really does ask all the critical questions. These topics I've covered to some degree. I'm going to go through them again in about 3 seconds. Lawful source of funds, OFAC in regard to Iranians, Syrians, important issues, in terms of proving where do you get the money from. These are, I actually just blogged on this as well, common issues in source of funds reports, salaries, retained earnings, gifts, tracing the money, all very important aspects, specific China restrictions, the 10 friends and family, actually not so much anymore. We need to update the slide because we're seeing direct transfers with Bank of China. So that tactic is, that slide needs to be updated. I want to get into, we've already heard Kevin Wright of Wright Johnson, EB-5 Economic Trends. He is what I call the guru when it comes to filing regional centers, preparing economic reports, business plans, etc. So meeting the requirements, Kevin, what you're referring here is meeting the requirements for eligibility to get a 526 approved. You have already spoken to some degree about qualifying. This is about, so we've now done our due diligence with Michael Gibson. We've worked with Jor and we've set up our corporations and we've done everything according to the book from a securities point of view. I haven't plugged my own role, which is the immigration lawyer, the quarterback, putting the team together, getting everybody to work, making sure that everybody plays nicely in the sandbox and that we work in the client's interest. If it's a regional center in terms of setting it up, if it's a direct or standalone in terms of making sure all aspects of the project are going to be successful, and meeting the requirements to get the 526 approved. So, Kevin, you spoke briefly about this. Tell me, clarify again, what is it you're specifically looking for and what is CIS looking for, and how are you helping us prove that we meet the requirements to get our 526 and 829 approved?
Well, I would say basically the meaning of this slide is that what everyone focuses on in the economic analysis is the gain in employment and the amount of jobs that are there, because that determines the amount of money raised. However, if you read the regulations, there are a lot of other things that need to be proved in an economic analysis as well. And if you don't have those, you're going to draw an RFP and bring them in. You know, changes in output, changes in the utilities, changes in indirect business taxation, and other sections of the economic report that don't get talked about much because everyone just kind of glances over them. They are important because if you don't see those in the report, the I-526 is going to draw an RFE, and you're going to have to go back in and to update all of those things. So it's important to have every last thing that's mentioned in the regulations to be included in the economic analysis, not just the employment gain.
Now, Kevin, we've already covered several of these and we're running low, but some of the critical RIMS 2 data discontinued. We'll probably get into that in more detail as we go down. Tenant occupancy round 2, you know, let's call that almost a knockout. That's a KO. We spoke earlier about the 2013 policy memo and how that impacted industry sectors, so-called NACE codes and geographical area amendments. Construction timelines, that's a topic we can't really cover in less than 15 minutes. We're going to go into the weeds on that in future, whether it's more than 2 years, less than 2 years. I keep hearing, oh, the project has to last more than 2 years to count. And then now we see that we want to see construction completed within 2 years is favorable. And this verifiable detail, CIS driving regional centers beyond the pale of sanity, requesting expensive feasibility studies and proof of industry standards. These are some of the hot issues that I know you deal with in your reports. So this is a topic we're going to deal with in some length in future. we can get into some of these juicy topics like manual deflation of the models and tenant occupancy. You know, this has been a huge mystery for a lot of people. When it first came out, I guess in February 2012, about 60% of projects at the time were impacted. Fortunately, those that had 526 approvals, you know, there was deference and they surviving and getting through it. I know this is a topic that's the subject of litigation. Can you summarize for us, Kevin, what you mean there? Round one, round two, this sounds like a boxing match, and I'm not sure who's winning, but summarize where we're going with tenant occupancy, who's winning, did the government cave in on this?
Well, basically we have further clarification now, but tenant occupancy started in February 2012, where basically the USCIS came out and said that, you know, previously what you would do is you would build a retail strip center or an office building or something, and you would count the employees of your tenants, and you would use that for your job count in order to raise EB-5 funds. And the government came out and said, well, those employees are really your tenants' employees, not your employees, so we don't want to count them anymore. And as you say, that affected over 60% of the industry at the time and caused huge delays and a huge backlog of projects where people didn't quite understand what to do. The government left open the door and said, well, you can come back in, and if you can prove that because you were building this particular office building, then new businesses were able to be established, and therefore your building is causing employment to be created. So a lot of people responded to that RFP by using feasibility studies and other outside sources to show that, hey, there's a lack of the appropriate space that's needed here, so therefore we are helping to create employment. And that generated a second round of RFPs where basically the second round said, well, okay, you've shown that there's a need for the space of an office building, but you haven't shown that there's a need for that specific type of tenant. That becomes very difficult because now you not only do you have to prove that there's a need for specialized office space, but you have to show that there's a need for each potential tenant that you might rent to in the building. And it becomes very difficult because there may be a lack of office space for creative or tech company, but there may be plenty of options for a law firm to move into. And therefore, you could prove the need for those tech companies, but you couldn't prove the need for the law firm. And you could not then rent to a law firm, or you could not get that passed. Basically, what we've seen is that any type of tenant occupancy project is really not preferable and not something you want to try because the amount of those that get through these days is very low. We've had success only in build-to-suit projects recently, where you may have a particular tenant who, like for example, we had a national pharmacy chain that wanted to move into a particular neighborhood, and that neighborhood was zoned as a historic district, and there was only one building that opted out of the historic designation 20 years beforehand, and therefore that was the only building in the entire neighborhood that could be used for a business. Well, in that particular case, they allowed it to go through because the tenant either built in that particular building that the developer owned, or they couldn't build in that neighborhood at all. But that's a very rare case and very specialized, whereas most cases are not approved on tenant occupancy anymore. They instead allow you.
Sorry. No, please finish.
I was just basically saying that they've kind of come up with an alternative that they'll accept, which is they will allow the construction jobs to be counted for EB-5, and they will allow the jobs that occur from leasing and management because the developer directly hires those people, but not the jobs associated with the tenant.
Kevin, what you just said is worth $1 million, particularly if folks knew about this in February 2012, because nobody could predict the future with regard to round one, round two, or what kind of proof would be required to respond to these RFEs. Bottom line is we're seeing a huge shift towards hotels and assisted living facilities because that's what's working, and shopping centers not so much unless we have this very unique build-to-suite requirement. So doesn't look like the developers won that. Looks like CIS, but that saga is not over. It's going to end up in the courts. We'll talk a little bit about this next time. Construction jobs, you touched upon this, and I'm probably going to get into this in more detail. I'm just watching the clock, and I know folks want to, I'm doing this again to you. I leave you at, I always, what can I say, Kevin? I leave the best for last, and we don't get through it, but this is the teaser for the audience that you're going to have to sign up for September the 18th. And by the way, please tell your friends to sign up because the reality is, there's a lot of webinars on EB-5. I don't think too many are providing this kind of in-depth, valuable information on free webinars. There's a couple you can sign up for $200 or $300. And here you're getting Kevin, one of the superstars, in my opinion, on job projections, what works, what doesn't work, three of the absolute experts in their particular arena. And I rely on these folks heavily when preparing and filing 526s and 829s as well as 924 regional centers. So questions for Kevin, questions for the rest of you, and I need to bring my tech guy in here. We're a few minutes past. Please like us on Facebook. Let's see how we're doing with regard to questions. How many do we have? Whoa, this is a long, long list of questions. I'm going to try and fly through them. So, Michael, you've got some personal comments from some of your friends. We'll keep them anonymous. This is Peter Allen. Hey, Peter, what is the biggest problem with a direct as opposed to indirect investment with a regional center? I think the biggest problem, I'm going to answer some of these, see if I can get through them quite quickly. The biggest problem with a direct is creating that 10 jobs. How do you actually create that 10 full-time jobs for $500,000? Thank you for the joke. Somebody says that Michael's also using a 10-year-old picture. I'm going to debate that. I saw Michael quite recently, and I think he looks younger in person than he did in that picture. So there you go. Have the Regulation D requirements been eased by Congress? Well, I don't know if that came in before we addressed that. Jor, do you want to take that? Have the Regulation D requirements been eased by Congress? It seems like a generic question. I thought we got it.
Can you ask that again? I want to make sure I heard it correctly.
It's just a very simple, plain question. Have the Regulation D requirements been eased by Congress? I think you addressed it in your presentation, but...
Got it. Yeah, I mean, it's continuing to be changed, but the Jobs Act legislation that opened up general solicitation, that was signed into law on April 4th, so past the Congress stage, but it's not effective until the SEC makes the change. The SEC adopted the final rules on July 10th and said they would be effective September 23rd.
Got it.
So September 23rd is the date you really want.
Somebody, this is being the topic of discussion, says Jor still looks 21. Actually, he gets carded all the time, but he's really much older than he looks, as is Kevin, also looks about 16 in the picture. These guys are actually relatively old guys, but they just don't look it. A few more years and they're all going to have gray beards and gray hair practicing in this arena because that's the way it is. A lot of stress here. So I've never heard him
21.
be wrong. Wow, you've got real fans here, Jor. I'm impressed. Let's see. What about the argument that $400K in income this year equals average income of 200K for the last 2 years. Jor, can you average out when we're trying to prove that we're an accredited investor? I made 400 this year and 0 last year. Can I average out and say that's 200 a year?
No, you can't. Of course, if it was your own business and you paid yourself $200,000 on December 31st and $200,000 on January 1st, then you could do it. But no, otherwise no.
So, Michael, we've got a question for you. Does your firm provide ratings for projects akin to what major firms such as Moody's provide for debt issuances? Do you do triple B? How does your system work?
That's a great question, Bernie, and I appreciate the question from the audience. We have just started to do that, and it's we're trying to still maintain our independence with the issuers. So what we've done is we've engaged, and I'm so happy you're bringing Elliot Weiner onto the conversation next month. He's part of our team who's going to be helping assist us do that, especially with regards to the TEA. So yes, we've brought in a number of third-party firms that also do due diligence, and we have a package for the issuers who want to go to China and present their projects and say to the agents and to the investors that the project's been vetted by a third-party organization, and that way that the agents and investors overseas can take comfort that a third party has looked at this and has verified some of the claims. So the answer is yes. We haven't gone to market with it simply because we're taking baby steps with a few of our the people we've been working with for a while. But the answer is yes, and I would say it would go into general publication sometime in the fall.
Excellent. We have a question here from a very experienced EB-5 lawyer. It's to Michael and Jor. How effective, if at all, are disclaimers or waivers to protect attorneys from securities liability? So all those disclaimers and waivers, can the prospective investor waive liability?
Not really. It depends on what sort of liability, but generally, no. For example, attorneys cannot have the clients waive malpractice. An investment advisor cannot go to their client and say, you waive the fact that I have no license. So it really depends on what waivers, but my guess is, not knowing what the question asker was thinking, it's probably no.
And Bernie, I would just add, I think that I'm in New York right now, and I think there are litigators who are starting to come into this field, and we get calls from them quite often, and they disregard these disclaimers. I think immigration attorneys have been using them for years as a shield, but my sense from speaking to the litigators is if this goes to trial and they put up experienced immigration attorney on the stand, and then they put up grandma from China who doesn't even speak English, and the attorney says, well, they should have done the due diligence themselves. I don't know if they're going to find comfort in that defense, especially using this liability or disclaimer, the limitation of liability waiver. And I think that could cause some problems. I think the best practice that again, you have been highlighting since I've known you doing these webinars is by doing best practices, by actually taking due care for your clients, and that would be probably the best defense.
Got it. Question to you, Kevin, regarding geographic and industry scope of the regional center. Has CIS, USCIS, released any further info or made any decisions that help clarify either, or can we only rely on the May memo for now? To my knowledge, we're relying on the May memo for now. I haven't seen any additional clarification. Kevin, any comment on that?
Just that, yeah, I would agree with that. I mean, there has been no further clarification. It would seem like there has been no stakeholders meeting with USCIS in some time, and I would expect a lot of questions to come up about this at the next stakeholders meeting. But as of now, no, there's no further clarification.
That's assuming there will be further stakeholder meetings. The regular quarterlies are out. I tried to skip over this because of time, but the question has come up, so let's answer it. What's the practical impact of no longer having a RIMS 2? I don't know what that is. Opinion, I think it would mean input. After September 2013, do you see that decision being reversed once sequestration is addressed? That's an extensive topic, but impact of sequestration on RIMS 2.
Yeah, the basic answer is, I mean, I don't know that anyone knows whether they'll bring RIMS 2 back or they'll remedy that situation, but with what we have to date, you know, as long as the person who does the economic impact report deflates the numbers correctly going out into the future, at least for the near term, you should be able to continue to use RIMS 2 data based on this year's data as long as you deflate correctly. However, there is no clarification from USCIS whether they will understand and take the same viewpoint. So I would say that although RIMS 2 will work fine in the future, you know, other remedies would be to switch to the in-plan and read-on model.
Got it. Thanks. Escrow or refund? What are the current trends in allowing investor funds to be released from escrow? Well, I don't know if it's escrow or refund. Escrow provides for refund if, in fact, the 526 is denied, at least in most cases. The trend that I'm seeing on bigger projects is that once a certain number or percentage of 526s have been approved, a percentage of the money will be released from escrow. I'm going to try and go through some of these questions. I always like to get every question answered, but I'm also respectful of your time, so we'll try and do short answers, which by definition will not be accurate. How do we market to foreign nationals who are already on U.S. soil under some other status, for example, foreign national in the U.S. on an E visa or H visa? How do we market to these folks without forfeiting Reg S exemption? Can promotion in the U.S. originate from abroad and satisfy the requirements? For example, a website hosted overseas, for example, or social media promotion by offshore marketers. You want to comment on that, Jor?
So wait, say that again. Can the
how do we market to foreign nationals who are already in the U.S. without forfeiting Reg S exemptions? And specifically, they're asking, can the promotion in the U.S. originate from abroad? For example, hosting off-site, scratch that, hosting overseas, or social media that originates from offshore. Does that provide any additional advantage for project promotion?
I want to say generally the answer is no. It's actually two things. It's one is that you cannot sell to a U.S. person. The second one is that you cannot condition the U.S. market. So if you are not conditioning the U.S. market, but you still sell to a U.S. person, you still violate Reg S. If you sell to a U.S. person, if you sell not to a U.S. person, but you've conditioned the U.S. market, you've also violated Reg S. So for example, if you held a webinar or seminar in the U.S. That targeted U.S. people, you would be conditioning the U.S. market, even if ultimately you didn't sell a single transaction to any U.S. person.
Thank you. Another question here. What is approval time for new regional center application, 6 months or a year? We don't really know because, many of them have been taking 1 to 2 years. I think from a planning point of view, you probably want to look at a year. We're going to be hopeful that when Washington's up and running, down to 6 months. I'm getting anecdotal reports that regional center applications are being approved a whole lot quicker. Let's see, we're going to fly through these. My concern is the time 526s and 829s are taking to get approved. It's taking longer. I thought they've hired more people and should get this down to less than 6 months. Wishful thinking. 526 takes about a year. Yes, that's true. And about the same for 829. Yes, that's true. When do we expect the time to come down again? I'm not expecting it to improve much this year. I'm hopeful that by the beginning of next year we'll see some kind of approval. Question to you, Jor. Thank you, gentlemen. Can regional centers take equity positions in their projects? What do you feel, Jor, about a regional center taking an equity position in their own project or in a project that is within their jurisdiction?
Well, I mean, a lot of projects are 100% owned or affiliated with the regional center if they do their own projects. If they don't do their own projects and they take equity, to me, that itself isn't an issue. It's just a matter of what are they receiving equity for is really what I care about. But to the extent the regional center is getting compensated for legal services that it's actually providing legally, then, you know, I don't really care if they take equity or not, and whether that's a good idea or not is really probably beyond the scope of this phone call, because that goes into all sorts of, you know, corporate law issues, as well as, you know, whether it makes sense, because now instead of getting cash, you're getting a something that's tied to the future performance and growth of a project, and maybe you're not qualified for that. For example, lawyers that charge hourly and get a cash fee, that's something they understand. When they start taking equity in their clients, other than ethical issues, you know, sometimes that hasn't worked out for law firms that didn't know that the equity they were getting was not as valuable as the cash they would have gotten.
Yeah, but again, I just answering it, it is very normal for regional centers to have their own projects. So I guess the question is taking equity in other people's projects, and, you know, I guess if they this is fully disclosed, and it would be an acceptable practice. Let me just get through these last few questions. Essentially what I'm getting at is that a single 500K gift does not make you an accredited investor. So if your rich dad is going to gift you EB-5 investment money, have him give you half for Christmas and half for New Year. Jor, this would be going to you. So if your rich dad is going to give you a gift, and we're talking about an accredited investor, have him give you half in December and half for New Year. That way they have over 200,000. I suppose it's not exactly income. It really should be net worth. How do you feel about that, Jor? If Daddy gives you 250 on December 31 and 250 or 300 on January, or do we meet the accredited investor provision?
No, I think you nailed it on the head, Bernie. That's not income. That's a gift. All that matters there is net worth. Now, if you're going to do income, then theoretically there would be something to support that it truly was income. Maybe, for example, a company was set up and then a W-2 was given that showed that he actually someone really got that income, but a gift itself does not constitute income.
So thank you. Boy, so many. Then a gift 5 does not meet either requirement is kind of what he's saying. I still think we're kind of in untested area when it comes to kids, and whether or not there's a problem in this arena. Hopefully there will be clarification and a carve-out, because a very large percentage of these cases involved gift from parents to kids who then make the investment, and the question is whether or not that is going to be permissible. Just quickly running through, U.S. person versus persons residing in the U.S. Is an H-1B a U.S. person? Jor, do you want to take that? I think if somebody's on an H-1B and they've been in the United States for 2 years, they would be covered as a U.S. person, but I defer to you.
So yes, the guidance for who a U.S. person is under securities law is not quite as clear, but I think in that case, that's probably, even under immigration laws, I think they'd be considered a resident here. I've heard that some immigration attorneys say that, oh, well, maybe they're not technically residents, but even if that was the case, it's a gray area, but it seems that the SEC would consider them to be U.S. residents and therefore a U.S. person.
Of course, they're not residents in the concept of green card holders. They certainly can be tax residents, but of course you have to look at the specific treaty because there are situations where H-1Bs are not tax residents. Well, I like this one. I'm going to repeat this. Wow, thanks so much for answering so many of my questions. Yep, it's a complete pleasure. What I'm going to do, however, is we've run over time. I hope all of you look at that. Wow, very strong attendance still there. We're going to continue this series. We're going to bring in other investors. I encourage you to reach out to my guests today. I enjoy working with these folks. They're all very direct, very knowledgeable, and certainly keeping us very busy. Demand for EB-5 is increasing pretty much on a daily basis. So after 2 hours of joyful interaction, I apologize again to my guests for not getting through all of their slides, but until September 18, hopefully you will be referring this to your friends, and we're going to have a real party on September 18th with our TEA specialist and the current guests as well. Hopefully they'll be able to make it. So thank you everybody for joining us. It's been a real pleasure working with you today, and until next time, you want an update? It would be great to hear updated information about growth of the non-China market. Yep, Brazil, India, Russia are moving, Venezuela as well. This is still, Mexico is going to come online. I just returned from my native South Africa, but the reality is Vietnam is going to be the new China. Vietnam is the new China. Watch Vietnam and Cambodia. But 75-80% of the business is still coming out of China. There answered your question, and until next time, everybody, thank you so much for joining us. Really a pleasure having you online, and maybe have a chance to work with you in the future. Take care. Bye.